Hello, I'm going to do a lecture on the separation of powers within the UK Constitution. So first of all, the UK claims to have separation of powers, and to a large extent it does. The separation is not absolute. Many countries say they have it, like the United States. Even then, the executive has a role, and so does the legislature have a role in picking the judiciary. Anyway, there have been significant structural reforms over the past 2 decades with regard to this. I'll delve into more detail a bit later on. So I have to look at how separation of powers is manifested in the United Kingdom and to examine the relationship between the judiciary, the executive, and the legislature. Of course, there's more than one legislature. So the judiciary, we know that means judges, courts. The executive, that's the Prime Minister, the Cabinet, and others who hold executive power. For instance, the First Minister of Northern Ireland, the Deputy First Minister of Northern Ireland, the First Minister of Scotland, the First Minister of Wales, the Mayor of London, various other mayors. So those who have the power to order things, to say execute it, like a business executive. That's what it means. Execute, in this case, does not mean to kill someone consequent upon a judicial decision. And legislatures, as I'm sure you know, these are law-making bodies, elected bodies such as Parliament at Westminster, the Scottish Parliament, the Northern Ireland Assembly, the Welsh Assembly, the London Assembly, various county councils, city councils, and so forth. Right, so it is important. Lord Acton, his most commonly quoted sentence, wrote in a letter, "Power tends to corrupt, and absolute power tends to corrupt absolutely." So often misquoted as "power corrupts." So good person can turn bad. Goes back to what Aristotle said. Imagine you had a cloak that you could put on, and that give you the power of invisibility. So you could commit any crime you wished and be sure to get away with it. Would you abuse that power? It would be awfully tempting if someone was going to steal from someone, be a peeping Tom, exact vengeance on someone, do all sorts of mischief, knowing that you would never be brought to book for it. And so that's why we can't make politicians or anyone else overmighty. We must make sure that their power is trammelled. Otherwise, they would succumb to the temptation to misuse it, right? They would abuse it for their own wicked ends. So this is what Montesquieu said in The Spirit of the Laws. When the legislative and executive powers are united in the same person or body, there can be no liberty. So he's writing in 17th century France, which is almost an absolute monarchy. So this is an idyll which has been around for millennia. So there's a Declaration of the Rights of Man and of Citizen in France in 1789, when their revolution was kicking off. So it says that any society in which the separation of powers is not observed has no constitution. And only in the late 18th century did European countries start to get constitutions. Until then, it was really, my word is law by the king, or as Louis XIV said, l'état c'est moi. So there's not total separation, as we shall see. There's some sort of interaction between them. We could look at the American model. So their constitution, Article 1, saying that legislative power resides in Congress, whereas Article 2 grants executive power to the president, and Article 3 says that judicial power is in the hands of the Supreme Court. There's separation of personnel. Although you having been a senator, for example, you could be made a Supreme Court justice. That's happened, although not in recent decades. So Article 1 says, no senator or representative shall be appointed to any civil office under the authority of the United States. So, people in the cabinet in the United States, they can't be also in the House of Representatives or the Senate at that time. They can formally serve there, but they can't be in both at the same time. So there are checks and balances. So we have to ask ourselves, is total separation of powers desirable? Is it even achievable? Possibly it is. But I can't think of a country that's got complete separation of powers. There's going to be some crossover between them, so that they're meant to check each other to make sure nobody becomes too powerful and nobody can really misuse their power. We sort of damage limitation when you have someone like Trump at the top of the tree. There's no end to the havoc he could wreak. So it limits the harm that he can do. Limits the power, the harm that, say, the legislature or indeed the Supreme Court can do. We don't want critarchy either. That's to say, ruled by judges. So there's a presidential veto of legislation in the United States, but that can be overridden if there's a two-thirds vote of both the House of Representatives and the Senate. So Congress, they scrutinize the people the president appoints to various offices. They have hearings, and they can block the person. They can vote, no, we're not having them. That's why Judge Kavanaugh had difficulty getting confirmed. Famous in the 80s, Robert Bork did make the Supreme Court President Reagan's nominee, thought to be a reactionary. But the very fact that the president nominates Supreme Court justices suggests that obviously proves that the executive has some say over the judiciary, and indeed so does the legislature, because the Senate could stop these people being appointed. Okay, so we know there are those three things: judiciary, executive, legislature, and they overlap a little bit. Now let's look at the executive. Well, the people, the Prime Minister, the Cabinet, they're all in Parliament, most in the House of Commons, a few in the House of Lords. So what did Barrett have to say about it? There's no effective separation of power between the legislature and the executive in the UK system of checks and balances. Lord Hailsham in 1978 lamented the elective dictatorship we had. Now, he was a Conservative writing in the years of a Labour government. As soon as the electorate ushered a Conservative government into office, suddenly this problem about elective dictatorship disappeared for him. He didn't complain. He was Attorney General for the next 8 years, and suddenly the scales fell from his eyes. It was a Damascene conversion. He saw no need to update the situation. He was very happy when there's a Tory majority. Bagehot said all this, the fusion of the executive and the Parliament was the efficient secret of the UK Constitution. Bagehot believing that the distinction between them could not be described with microscopic accuracy, as he put it. So perhaps it's a cause for concern that some people hold both a legislative and executive power, because you're a member of the two branches simultaneously. There are about 95 ministers, that's to say cabinet ministers, roughly 25, and for each of those there are 2 or 3 junior ministers. So remember, a cabinet minister usually has the title Secretary of State, as in Secretary of State for Education, Secretary of State for Transport, etc. That's a bit of a mouthful. We usually just say Education Secretary, Transport Secretary, and so forth. But beneath each of them, there'll be a Minister of State. Well, a few Ministers of State. If it was like, say, Education, Secretary of State for Education, below him a Minister of State for Universities, a Minister of State for Secondary Schools, a Minister of State for Primary Schools, and so on, dividing it up into areas of responsibility. So about 95 ministers, the payroll vote to get higher salaries because of the duties they're carrying out, and their parliamentary private secretaries and other MPs, a bit of a sidekick to one of these people. Not to be mixed up with a permanent private secretary, a civil servant responsible to these ministers. There's also delegated legislation, which is these statutory instruments which are passed, empowering a minister to make laws about this. So that, and arguably, that is allowing ministers too much power to just sign things into law without further debate. Is it really a bicameral system, the UK Parliament? Because remember, the House of Lords only has the power to delay things for a year, pursuant to the Parliament Act of 1949, and again has no say whatsoever over money bills. And of course, the House of Lords is not properly elected. The only people who have ever been elected to it are the 89 representative peers representing the 800 hereditaries. In 1999, the Labour government under Blair rushed to stage 1 of Lords reform, getting rid of the great bulk of hereditary peers, allowing 89 to stay. And that's merely a temporary measure. 21 years on, we're still no nearer to stage 2. Nobody's come up with a comprehensive plan about stage 2. What was a rush to stage 1 if you've got not the foggiest idea what to do about stage 2? And every time a hereditary peer who's representative 1 dies, then the others, or could resign, could choose not to be a representative peer. The 800 hereditaries can elect whoever's going to fill that position. Just because the Earl of Bloggs dies, his new son is the new Earl of Bloggs. The new Earl of Bloggs doesn't necessarily get to be a representative peer. He might not want to, and it's the other 800 vote who's going to fill that vacancy. Anyway, should we have an elected House of Lords? That's another debate as well. Maybe that would simply replicate the House of Commons. If it is to be elected, have to be elected, I suppose, not on a geographical basis, because otherwise, again, it would simply be a mirror image of the Commons. Do we want yet more politicians? Probably not. Anyway, so I don't want to get mired with that one. So there are parliamentary checks on the executive. But there's a big parliamentary majority of the governing party. They can get through well nigh all. You might think that's good. You might want strong and decisive government. You don't want it palsied you don't want it too enfeebled. It was a coalition government, 2010 to 15, the Conservatives and the Liberal Democrats. And 2017, the Conservatives and the Democratic Unionist Party had a confidence and supply agreement. The Democratic Unionist Party would support the Conservatives in a vote of confidence. They would vote through whatever taxes were needed, but they wouldn't promise to vote for all the legislation that the Tories were proposing. So they didn't go as far as a full coalition. Remember, the Conservatives didn't quite have a majority and relied on those 11 or so DUP parliamentarians to help them out. Anyway, so how accountable is the executive? Well, obviously, there are questions, there are also debates. There's Prime Minister's Question Time, which is very theatrical, 12 noon on a Wednesday for half an hour. There are also select committees, roughly 20 MPs with specialist knowledge, special interest in a particular area, like finance or foreign affairs or something. And they can call people as witnesses, they can commission reports and so on. We also have ministerial responsibility, so they're answerable to Parliament, the House of Commons, the House of Lords, whichever one they're in. They have to be in one of those two houses, so they can be questioned there about what they're doing and what they're doing wrong. Anyway, we could wonder how much reform is needed. Well, there was the Constitutional Reform Act of 2005, and the key provisions of that were to make the judiciary more independent, have a Judicial Appointments Commission, and the Lord Chancellor's role was really changed. Partly this is pursuant to a case called McGonigal and United Kingdom. The Judicial Appointments Commission, seeing is a person of integrity, worthy to be a judge, obviously has to be a solicitor or a barrister, usually the latter, sufficiently experienced, a person of good repute and all the rest of it. But the trouble is, isn't that just picking more people like themselves, pale, male and stale, and with certain attitudes? And the Supreme Court was set up in 2009, but that's pursuant to that 2005 piece of legislation. And so the Lord Chancellor was no longer actually functioning as a judge. He's now Lord Chancellor and Secretary of State for Justice. They were almost always barristers beforehand. Lord Tony Pandy was an exception to that. But then after that, they became they no longer have a judicial role. Sorry, I'm talking about the Speaker. Lord Tony Pandy was Speaker, and they usually were barristers that filled his office. Anyway, what reforms might be coming in the next few years? The Attorney General's role as the government's barrister is contentious. Look at Lord Goldsmith in 2003, who gave legal advice about military action against Iraq, and that wasn't published for a very long time. Some people think it was wrong that the Attorney General was doing this. He's part of the executive, part of the legislature. He's a political appointee. Perhaps he was too partisan. So he's the main legal advisor of the government. And he also supervises the Crown Prosecution Service, as they decide whether to prosecute you or not. Once the police are charged with the crime, he can issue an order of nolle prosequi, do not prosecute. Remember, Keir Starmer was head of the Crown Prosecution Service for a while. Sir Keir is now leader of the opposition, the Labour Party. So the Attorney General is a minister, but he's not in the cabinet. He's in the Privy Council though, so he's the Right Honourable before his name. So what did Lord Diplock have to say about this celebrated judge of the 70s? It cannot be too strongly emphasised that the British Constitution, though largely unwritten, is firmly based upon the separation of powers. Parliament makes the law and the judiciary interprets them. Well, that's a classic statement of it, that last little bit, although there's some people who disagree and say no, judges can make law too. And there was a case about this, Duport Steeles and Sirs in 1980. That's where he said that. So let's look at how the judiciary interacts with the legislature. Statute trumps common law. All right, that was laid down by the War Damages Act 1965. This is when Burma Oil, it was Burma Oil and Lord Advocate. The Lord Advocate being a judicial office in Scotland. So the courts can't strike down a law like in the Republic of Ireland, where we can find that a certain law is repugnant to the Constitution, it's struck down. Now, mostly that's referring to laws that were passed prior to 1921, when we're part of the United Kingdom. So what is it that checks the judiciary? Perhaps it's Parliament could pass a law doing this or that. Now, this is contentious, this aspect of the Constitution, because perhaps it undermines legal certainty. And does it impugn the rule of law? Again, arguably it does. So there was a case about this in relation to job seekers, the Back to Work scheme in 2013, when someone called Riley was litigating on this issue. Okay, so we see how common law develops. There's judicial deference, as in deferring to Parliament and deferring to previous decisions, but there's also judicial activism. Is that wrong? Are they pushing a partisan agenda and they're overstepping the bounds of propriety? They ought to stay within their appointed limits. Their sphere is judicial, and they mustn't stray into the political arena. If they want to be in public life, they must seek election to some legislative forum. So again, arguably there is judicial activism. There was R&R, a 1991 case where English law said that it was impossible to commit rape within marriage if a man had intercourse with his wife against her will, even if he acknowledged that, swore on oath, yes, I did it against her will. That was no crime in English law. It was a crime in Scots law. That was amended by legislation in the early 90s. Or Gillick and West Norfolk Housing Association, 1985, said to be another example of judicial activism, a judge pushing a partisan viewpoint, which many might agree with. Maybe it was a good thing, but is it right for a judge to be doing this? Because perhaps he's usurping the legislative role. Or Airedale NHS Trust and Bland, 1993, this is about the right to die for someone who's brain dead after the the Highbury disaster, that Sheffield Wednesday versus Liverpool match where all the people got asphyxiated. Okay, so looking at judicial deference, the idea is that you don't create law if you're deferential, you leave that up to Parliament. Malone and MPC in 1979 was about this, or R. Nicholson and Ministry of Justice 2014, another controversial case. So we have to think about how they judge in a certain context. Some judges are more activist, and they think they've got certain areas of competence when they're right to be like this, about individual rights, about minority rights, to do with legal standards, and areas touching common law rules. But in certain sectors, the bench is usually more deferential to Parliament, especially where they feel it's more apposite that a certain issue be decided by Parliament because it's an elected body. Okay, so what's clearly a political competence is anything touching an explicitly political matter. If it's a question of ethics, it's about socio-economic resources, spending, money, welfare benefits, anything to do with secret intelligence or security information, military affairs. All right. So there was the Act of Settlement, 1701, giving judges tenure until retirement age. During good behaviour, their salaries couldn't be decreased. So what's good behaviour? They commit a crime, they're out. Things which are thought to be unbecoming, like picking up prostitutes, for example, they're out for that one as well. Whether they refuse to resign, can they be dismissed? I'm not absolutely sure about that one. I don't know of anyone who stayed when they thought that they shouldn't. There's also immunity from lawsuits in Syros and Moore, 1974. You can't sue a judge for making the wrong decision, even if subsequently by a higher court said, no, that was a wrong decision, he erred in law, or he was just unfair. Or if the judge takes a bribe or something, well, that's different. They can be jailed for that, and it's happened. Okay, so that you can't decrease their salaries because you don't like the decisions they're making. They make a ruling which is uncongenial to the executive. The executive can't boot them out, otherwise they would simply be rubber stamps. So there's genuine independence, something which countries in which dictatorships find generally hard to understand, genuinely hard. Okay, so how does the judiciary interact with the executive? We know there's judicial review, and there are common law grounds of challenge which have been expanded lately, where you can take out a case against the executive saying they made an unlawful decision. Sometimes you win. Or M and Home Office 1993 would be an example of this. The Human Rights Act in 1998 stated that public bodies, under Section 6, cannot act in a way which is incompatible with the Human Rights Act. And so that obviously applies to courts as well. It applies to the executive too. And the court can issue a certificate of incompatibility and then leave it up to Parliament to resolve. So how does the modern judiciary behave? Well, there's R. Evans and Attorney General 2015, a case about this where Lord Neuberger was deciding it. And he said, subject to being overruled by a higher court or statute, it is a basic principle of the decision of a court is binding as between the parties and cannot be ignored by anyone or set aside by anyone, including the executive. There we see, close quotation, when the Black Spider letters were released, as in Prince Charles's handwritten letters to ministers trying to intervene this way and that way. So that's a very brief introduction to the separation of powers. Toodaloo.